A person who claims that a decedent revoked his or her will typically has the burden of proof in establishing revocation. However, a presumption of revocation arises when a decedent's will is found to be destroyed or obliterated upon death. In the 1993 case Harrison v. Byrd, the Supreme Court of Alabama considered whether such a presumption also applies when a decedent's will is missing upon death. In November 1989, Daisy Speer executed a will, naming Katherine Harrison as the main beneficiary of her estate. Speer's attorney retained the original will, and Harrison received a copy. However, a few months later, Speer called her attorney to revoke her will. Speer's attorney then tore Speer's will into 4 pieces and sent her a letter with the pieces of the will enclosed. Additionally, Speer's attorney advised her that the will was revoked. On September 3, 1991, Speer died. Upon her death, Speer's attorney's letter was found, but the pieces of Speer's will weren't. 2 weeks later, the probate court appointed Speer's cousin, May Byrd, as the administratrix of Speer's estate. Subsequently, on October 11, 1991, Harrison petitioned the probate court to have her copy of Speer's will admitted to probate. In response, Byrd filed a motion to have the case removed to circuit court, which the probate court granted. Byrd also filed an answer to Harrison's petition, arguing that the will shouldn't be admitted on the grounds that Speer had revoked her will. Both parties moved for summary judgment, asking the court to rule in their favor as a matter of law. Initially, the circuit court denied both motions, concluding that a genuine issue of material fact existed as to whether Harrison had rebutted the presumption that Speer intended to revoke her will. Later, the circuit court granted Byrd's motion, finding that Harrison hadn't rebutted the presumption that Speer revoked her will. Harrison then appealed to the Alabama Supreme Court.